9. Parcel remainder lands. It is becoming quite common to find the creation of airspace parcels and the subsequent subdivision of those parcels into strata lots. An airspace parcel is what its name implies, that is, a parcel created in the air. A landowner owns the fee simple surface lands, the area below the lands subject to any mineral rights, and up to the sky, theoretically. There is created in the sky a separate legal lot known as an airspace parcel. A building constructed in an airspace parcel needs to have supports, and these supports are to the land below. They will also need access rights such as stairwells and elevators, the provision of utilities, elevator shafts, fire suppression, and alarm systems. All of these come from the remainder parcel. When you are doing a lease of land, that is the remainder parcel, you will note that certain costs will be shared with the airspace parcel. These are likely costs set out in charges registered against title to the lands. You must be careful in considering these when looking at the common area cost provision, and may have to consider making some amendments to ensure that these costs are included in the lease definition of operating costs. Additional resources regarding strata developments in airspace parcels, look at the RECBC website and CHOA websites. And here is a diagram with some, let me shrink it here for a second. Alright, so there's a diagram with the airspace parcel, ASP in a residential tower. And here's a remainder, below is commercial. And here, the airspace parcel, ASP, these are townhouses. All right. 10, lease registration. We have previously touched upon the top line case and the issue of the subdivision of land as addressed in Section 73 of the Land Title Act and amended by Section 73.1. For this section, we will consider only registration of a lease forming part of a building or a commercial project, such as a warehouse or shopping center, in a land title registry. We will not consider registration of a lease of premises situated upon First Nations lands. Registration of a lease of premises situated on First Nations lands will depend on the specific First Nations lands. The reason for registering a lease is to give notice of the tenant's interest in the lands on which the premises are situated to purchasers of the land, mortgagees of the land, or other persons dealing with the land. There is, however, case law which provides that if a lease is apparent, even if it is not registered, there will be deemed to be notice of it. See Me and Ed's Pizza Parlor Limited versus Frontera Developments 1975 Limited 1975, 62 DLR 3D 148 BCCS. If the tenant requires financing, its lender may require, as part of its security package, that it be granted a mortgage of the tenant's lease. If so, for the mortgage of lease to be registered, the lease must be registered. Unlike jurisdictions such as Alberta or Ontario, British Columbia does not have a land title provision which permits the registration of a notice of lease, such as a caveat or a notice of lease. In British Columbia, for a lease to be registered, the lease as entered into by the parties must be registered, or what is typically done to avoid disclosure of the business terms, a short form of lease is entered into, and it is the short form which is registered. The short form of lease is not the business deal and is merely used as a tool for registration. The longer form of lease governs the parties' relationship. There needs to be a provision in the short form of a lease, or a separate document stating that the long form of lease and the plan attached thereto, setting out the area of the premises, prevails. The short form of lease will reflect the names of the parties, the legal description of the lands, and rent as $1 for the term of the lease, any renewals, any specific rights of the tenant, such as exclusive use rights, no build areas, and rights of renewal or extension. The Land Title Act sets out the form which must be used to register the lease. This requires that a Form C Land Title Act form be signed by the parties, to which there will be attached the form of lease, whether the long form or the short form, and that it be accompanied by an explanatory plan of lease prepared by a BC land surveyor. If the premises being leased are the whole of a building, including the surrounding lands, it will be necessary to register only the lease with a reference to the legal description of the land. So we're going to page 39 here. If the tenant is leasing a portion, it will be necessary for a land surveyor to prepare an explanatory plan of lease for the premises being leased. This plan must be filed concurrently with the lease. A survey can be prepared as early as when the foundations of a building have been poured. You will note in most leases that there is a prohibition upon the requirement of the landlord to deliver a lease in registrable form, or even making reference to a short form of lease. The reason for this is Section 5.2 of the Property Land Act, RSBC 1996, C377, which requires a landlord to deliver a lease in registrable form unless the lease states to the contrary. Section 5.2 states, a person who, as the landlord or intended landlord, makes the lease or agreement for a lease other than a lease or agreement for a term not exceeding 3 years, where there is actual occupation under the lease or agreement, must, unless the contrary is agreed in it, deliver an instrument creating the lease or agreement to the tenant or intended tenant in form registrable under the Land Title Act. So, if a tenant wants to register the lease or a short form, it will have to ensure that the lease permits it. Leases with a term of more than 30 years, inclusive of all extensions and renewals noted in the lease, are subject to property transfer tax if they are registered. If the lease is not registered, there is no tax. The Property Transfer Tax Act sets out a formula for the calculation of the tax, and it will depend upon the term. See Property Transfer Regulation BC Reg 74-88. In some instances, a party will register only up to the 30 years, even if the aggregate exceeds 30 years, so as to avoid paying the tax. The determination of the 30-year threshold is based on the aggregate of the initial term and the total of all of the extensions renewals. 11. Guarantor, Indemnitor, Covenantor. The landlord may determine, after undertaking its financial assessment of the tenant, that the tenant is not financially strong. In that instance, the landlord may seek to obtain from a third party, being the parent or operating company of the tenant, or an affiliated party, its covenant, guarantee, or indemnity with respect to the tenant's obligations under the lease, including the payment of rent. The basic differences between a guarantee and an indemnity is that an indemnity is a primary obligation, while a guarantee is a secondary or collateral obligation. Under an indemnity, the indemnifier is saying, I will pay you. Under a guarantee, the guarantor is saying, if the tenant does not pay you, then I will pay you. Under a guarantee, you usually have to make demand of the tenant prior to proceeding against the guarantor. The defenses are greater under a guarantee than under an indemnity. From a landlord's perspective, the indemnity is to be preferred. If a guarantee or indemnity is taken, the terms will also likely be negotiated. The guarantor or indemnitor will want to limit its exposure to either a specified dollar amount or a number of years. If a guarantee is to apply to an extension or renewal, it should specifically state this to ensure that it does not cease to have effect during the renewal. It is prudent practice to ensure that any guarantor or indemnitor signs any lease, extension, or renewal so that there is no misunderstanding that it is intended that the guarantor's or indemnitor's obligations will continue. Each indemnity and guarantee should also state that it survives the bankruptcy or insolvency of the tenant. The guarantee or the indemnity should preferably be set forth in a separate agreement so that in the event the lease itself is declared invalid, the guarantee or indemnity will survive. So we're going to 12. Sources of information. A Building Owners and Managers Association International. That's BOMA.org. We have previously discussed their criteria for area determination. B, BC Assessment Authority. That's bcassessment.ca. This will provide information as to the name of the owner of a property upon which the premises are located and the current taxes. C, Land Title Office, ltsa.ca. Search to confirm the registered owner and to advise if any registered leases or covenants which may negatively impact the tenant. D, BC Register of Companies, bcregistryservices.gov.bc.ca. This will confirm the existence of a corporate tenant or the registration in British Columbia of an extra-provincial corporation. E, Municipal or City Hall. This will provide information as to zoning. Alright, so the website is gvrd.com. It may be that the tenant's proposed use is not a permitted use under zoning bylaws. If that is the case, the tenant will not be able to obtain a business license. F, websites of various law firms. They may provide general leasing information and comments on current case law affecting leasing matters. 13, authority to lease. The authority to lease form is a contract between a landlord and real estate brokerage that gives the real estate brokerage permission to act on the landlord's behalf and to look for a possible leasee and negotiate the lease for the landlord's property according to the terms and conditions specified by the landlord. An example of the authority to lease form can be found on web forms as well as in Appendix C, page 79. Tenants Agency Exclusive Contract. It is recommended that the relationship between the tenant and the real estate brokerage should be in writing in the form of a tenant's agency exclusive contract. This will ensure that both parties will have a complete understanding of their rights and responsibilities. Each party will know what they can expect from the other and what is expected from them. This is similar to the common practice of landlords entering into a listing contract when leasing a property. Real estate brokerages cooperate with each other to bring tenants and landlords together. This cooperation will help bring their clients the best selection of properties which meet their individual requirements. An example of the tenants agency exclusive contract can be found on web forms as well as in Appendix D, page 83. And thanks for listening. Stay tuned.